Welcome back, everyone. I'm so excited to have you here for another explainer. Today, we are demystifying a process that, honestly, a lot of people assume is just this massive bureaucratic nightmare. But actually, it's highly structured and totally manageable once you know the steps. We're talking about the legal name change process right here in the state of Ohio.
So have you ever dreamed of transforming your identity with a new name? You know, whether it's for a fresh start, a marriage, a divorce, or simply just personal preference, legally changing your name in Ohio is simpler than you might think. Stick around as we break down the whole process, making sure you have the exact confidence and knowledge you need to navigate this life-changing decision.
Okay, let's dive right in. Here's our roadmap for today. 1. Eligibility and preparation. 2. Filing in publication. 3. Court and finalization. 4. Real examples and challenges. And finally, 5. Minors and special cases.
All right, Section 1, Eligibility and Preparation, laying the groundwork. Let's see if you legally qualify. Now this number right here, 60, this represents a massive shift in Ohio law. Up until very recently, you actually had to be a continuous resident of your county for a full year before you could even think about filing for a name change. But thanks to the passing of House Bill 7 back in 2021, that strict one-year residency requirement has been slashed down to just 60 days in your county. Basically, the Ohio General Assembly deliberately did this to cut out the red tape and modernize the whole shebang.
So, why do you want to change your name? Well, while something as simple as personal preference is a completely valid reason, the state absolutely draws a hard line at deception. You literally cannot change your name to run away from creditors. I mean, nice try, but no way. The same goes if you're trying to dodge a pending bankruptcy, if you're on a sex offender registry, or if you have identity fraud convictions. The courts are meticulously checking this stuff to make sure the process isn't being used for anything fraudulent.
Okay, so before you even head to court, you need the right toolkit. First up, you need a certified book copy of your birth certificate. This is absolutely crucial, folks. A simple little abstract just won't cut it. You need the detailed, long-form version showing the exact city and county of your birth. You're also going to need a valid, unexpired photo ID, like a driver's license or passport. Now, if your ID doesn't have your current address on it, you must bring secondary proof of that 60-day residency we talked about, like a utility bill. And lastly, if your current legal name doesn't match your birth certificate anymore, you've got to bring connecting documents. Think marriage certificates or divorce decrees. You basically need to show the court a clear paper trail of exactly how you got from point A to point B.
Moving on to Section 2. Filing and publication, making it official. Time to take those documents to the probate court.
Now, while the law is statewide, the actual day-to-day process definitely has some local flavor. Take Cuyahoga County, for example. Their specific filing fee is $130. You can pay that by cash or credit card, but they explicitly say no personal checks. They also highly suggest writing out your full middle name instead of just using an initial on your forms. So, the big takeaway here? Always check your specific county probate court's local rules for their exact fee structures and what payment methods they actually accept.
The main piece of paperwork you'll be submitting is Form 21.0, which requires a formal statement of intent and a notarized affidavit. On this form, you really have to provide a formal statement of your reason. Even if it's just personal preference, you need to write out something clear, like, "This is my preferred name, and I wish to obtain proper identification." Plus, the form includes an affidavit that has to be notarized. Oh, and a quick pro tip here, if you decide to use one of those modern online notary services, Ohio law actually mandates that the notary must be physically located and licensed inside the state of Ohio during that digital transaction. If they aren't, your whole application could get rejected.
Now, let's look at the old law versus House Bill 7. House Bill 7 eliminated one of the biggest, most annoying headaches of this whole process, mandatory newspaper publication. Under the old law, mandatory publication 30 days before a mandatory hearing was the standard. Everyone had to pay out of pocket to publish a notice of their intended name change in a local paper. It was expensive and honestly pretty slow. But now, thanks to House Bill 7, publication and hearings are now at the judge's discretion. This saves you so much time and money. A lot of straightforward adult name changes literally don't require a newspaper publication at all anymore. Though, just a heads up, some counties might still mandate it at an extra cost to you, so keep an eye out for that.
All right, Section 3, Court and Finalization, crossing the finish line.
So while a lot of cases these days are approved just by a magistrate quietly reviewing your paperwork, you might still have to go in person. If you do, you need to attend the hearing with your ID to verify your intent is not fraudulent. But seriously, don't panic. This isn't some dramatic courtroom scene from a TV show. You're simply going to stand before a judge or magistrate, hand over your ID, and answer a couple of super easy questions. They're really just making sure you are who you say you are and that your intentions are completely above board.
Okay, so once the judge signs off, you get your judgment entry. Boom! Congratulations, your name is legally changed. But you aren't entirely done yet. Updating your vital records requires a very specific order of operations. First, obtain certified copies of court order. Get several of them. Second, update the Social Security Administration. And great news here, they charge absolutely no fee for this. You have to do Social Security first because the BMV will actually check their database before giving you a new license. Third, update your BMV driver's license. Just take your current license and that court order in with you. And finally, step 4, update your U.S. passport.
Which brings us to Section 4, Real Examples and Challenges, Learning from Case Law. Let's see how this actually plays out in the real world.
Here is a pretty fascinating case from the 4th District in the matter of the change of name of Oba, which established that custom is not a sufficient ground for a name change. Basically, a father tried to change his minor son's surname to match his own. His argument to the probate court was that it's simply custom for a child to have the father's last name. Well, the mother objected, arguing it would just confuse the kid. The court ended up denying the father's petition. Why? Because when you're dealing with minors, custom just doesn't matter. The only standard the court cares about is the best interest of the child. Custom on its own is never going to be enough evidence to prove what's best for a child's well-being.
Next up is Decott v. Biggerstaff. This one teaches us a vital lesson about why you can't take shortcuts. The ruling here was that service by publication is invalid if a parent's last known address is actually known. In this situation, a mother wanted to change her daughter's name. The father lived all the way in California, but instead of formally serving him with the legal paperwork at his California address, which, by the way, she completely knew, she just published a notice in an Ohio newspaper. Well, the appellate court immediately struck down the name change. The lesson? If you know the address of an interested party, like a non-consenting parent, you literally must attempt actual service, like sending it via certified mail. You can't just hide behind a tiny newspaper notice if you actually know where the person lives.
And finally, Section 5. Minors and special cases, nuances in the law. The rules shift a bit here, so let's break it down. If you're handling a name change for a minor, the process is a bit heavier. First, you'll use Form 21.20 instead of the standard adult form. The 60-day county residency applies here too. But here's the tricky part. It requires the consent of both living parents. If one parent refuses or is out of the picture, you have to formally notify them, usually through certified mail. Also, keep in mind that background checks like BCI and FBI checks are required in some counties. Hardin County, for instance, makes you undergo and pay for these before they'll even look at a minor's application. And at the end of the day, you must prove the change is in the child's best interest. Judges rely on a specific set of criteria called the Wilhite factors to make sure the change genuinely serves the kid's well-being.
Now, what if you don't actually want a completely new name? Let's say your birth certificate says Jonathan with an O, but your social security card and driver's license say Jonathan with an A, and now you're stuck and can't get a passport. Well, House Bill 7 created a specialized, streamlined process for this. Let's look at name change versus name conformity. And name change is about creating a completely new legal identity. But name conformity, that's simply fixing a discrepancy or misspelling on official identity documents. It essentially asks the court to fix a typo across your paperwork so everything matches your actual lived identity. It's a lifesaver and a much easier route if you're just trying to fix a bureaucratic headache.
One final technical point. A lot of people ask, what happens to my birth certificate? Well, the probate court doesn't actually issue birth certificates, but the court forwards the judgment entry to Ohio Vital Statistics to issue a new certificate of birth with a footnote. So, if you were born in Ohio, within 90 days, the Bureau will issue a brand new certificate reflecting your new legal name. Now, it's important to know it will include a small footnote indicating that the name change was the result of a legal proceeding. It doesn't erase your history, right? It just legally and officially updates it.
And that brings us to the end of the journey. Are you ready to take the first step toward aligning your legal documents with your true identity? Look, while it definitely requires gathering some documents, navigating court forms, and taking a few trips to government offices, completing this process successfully offers such incredible personal empowerment. It gives you a clean, legally recognized, fresh start. I really hope this explainer has shown you that, with a little focus and preparation, this is a highly achievable goal.
Finally, I do need to share this reminder. This explainer provides general information about legally changing your name in Ohio and should not be considered legal advice. For specific legal concerns, consult with a qualified attorney. But you know, that does leave us with one final thought to chew on. If changing your legal name can completely shift how the government and the world sees you, what other outdated labels in your life are you ready to legally leave behind? Thanks so much for hanging out with me today, everyone. I'll catch you in the next one.